Jack, we started talking about the Second Amendment before we went to the break. Before we discuss this Supreme Court ruling on the Second Amendment and expanding of the gun laws in this country, or I would say putting some control on regulation of guns is going to make regulation more difficult. Can you tell us something? What is the Second Amendment? What do we understand by Second Amendment?
Okay, so it's very interesting. The Second Amendment is one of the more interesting provisions of the Constitution, and it has an interesting history. But excuse me, I knew that was going to happen. It begins by saying that mentioning a well-regulated militia. If you read the Second Amendment, it starts by saying a well-regulated militia being necessary, and then it goes on to say that the right to bear arms, the right of the people to bear arms shall not be taken away. I'm paraphrasing, but the reason that that's interesting is because the history of the Second Amendment comes out of one of the biggest arguments that happened at the time the Constitution was written in 1787 up till 1789. Because what happened was there was a big fight over whether the federal government should be able to have a standing army, or whether the federal government should just have the authority to call out the state militia if there was an invasion or some reason, an insurrection that they needed to put down.
So the state militia, was it a regulated army of the state, or what?
So yeah, the state militia was part of the states, and under the previous Constitution that we had for only a few years, called the Articles of Confederation, the federal government could not have an army. That it just relied on this individual, what they called the militia of the states. So the compromise was basically the Second Amendment, which was passed after the Constitution, but right after. The compromise was that the federal government could have a standing army, but the federal government could not interfere with the state militia. And basically, the definition of the militia is that all men of military age, at the time only men, would be subject to being called out to fight. And they would need their weapons either sometimes at home or sometimes stored in an armory run by the state, where they would go get them in case they were called out. Okay, so now, and in fact, allowing a standing army was so controversial that one of the framers of the Constitution, when he lost the argument against the standing army, he refused to sign the Constitution. His name was Elbridge Gerry, and he was from Marblehead, Massachusetts, right next to the town that I live in. And he's famous now, not for that, but for the fact that he also drew a crazy-looking district to make sure that he could get elected to Congress. And it's now called gerrymandering, because his name is Gerry. And only in Marblehead they call it gerrymandering, but everywhere else in the country they call it gerrymandering.
Gerrymandering, yeah.
So he refused to sign the Constitution because he didn't want the federal government to have an army. So it was always understood that the Second Amendment only restricted the federal government's right to regulate weapons, that it was up to the states to regulate weapons, that they were hands off the state militia and they couldn't regulate guns. But in the early 2000s, in a case against the city of Chicago, the Supreme Court overruled more than 100 years of clear precedent and decided that the Second Amendment applied to the states and local governments. It had already decided that the Second Amendment gave a fundamental right to own weapons for self-defense. That came up in a case about Washington, D.C., and Washington, D.C. is the federal government, so you didn't reach the question of whether it also applied to the states in that case. But in the McDonald case, which was about the city of Chicago's gun control, the Supreme Court decided that the Second Amendment also applied to the states, which seems odd to historians, but the Supreme Court had a new version of the history of the Second Amendment. And they did, this is part of the problem with Supreme Court decision making based on original intent, is that for many historians, they think the Supreme Court is pretty bad at reading the history, and that they just basically rewrite the history to suit their political views. And so as you get a stronger and stronger pro-gun movement in the United States, you get a Supreme Court reflecting that, and suddenly more than 100 years of law is thrown out the window, which says the law that says the states can regulate guns, and you have now the Supreme Court of the United States deciding on gun control.
So it was basically a debate whether federal government controls or the state government's control. How did it become a right of an individual? Was that after the Heller decision in 2008, when they said
Yeah,
that?
well,
Yeah.
yes, the Heller decision decided it was a fundamental right. That the best reading of the Second Amendment, based on history, was that the Second Amendment was intended to give people an individual right to own guns for self-defense, which in my opinion turns it totally on its head. Because in my opinion, the Second Amendment was about giving people the right to have guns available for use in military matters, that is, in the militia. So it's wrong, in my opinion, on two counts. Number one, because it doesn't apply to the states, and number two, because it had nothing to do with guns for self-defense. It had everything to do with military weapons. I'm not saying that I think people should be able to own, military weapons, but I'm just saying that it really wasn't about personal guns for self-defense.
So this interpretation that Second Amendment gives individuals a right to own guns to fight the federal government if federal government involves itself in tyranny on individuals or on the states. Where has that interpretation come from?
Okay, now that I didn't say that, and that actually, the right that they said was the right to own weapons for self-defense. Mm-hmm. Okay, and when the Supreme Court didn't talk about using guns against the government. But there are many popular groups that say that the reason for the Second Amendment is to prevent the government tyranny. But I don't think there's any private group of people, no matter how many weapons they have, I don't think there's any private group of people that are actually pose any serious threat to preventing the government of any state or the United States from executing whatever the laws that it wants to. So I think that's just sort of more of a rhetorical idea.
And if we go by that understanding, does that mean that individuals are allowed to have submarines, they're allowed to have tanks, nuclear weapons to be able to fight the state? Because state is much more powerful.
Right, exactly. It doesn't make any sense. And I think that it's one of the weaknesses of using the original intent to interpret the law and then applying it today is the idea that the Second Amendment, which was adopted in a time when weapons were pretty primitive, that it doesn't make sense to then say that we're going to apply that in a way that applies to now automatic weapons that can shoot hundreds of bullets in a minute. It's like saying that we're stuck with all the traffic laws from the days of the horse and buggy, because that's what the framers intended. So you can't have any traffic laws that are more restrictive than what would govern a horse and buggy today when you have automobiles, that can go 150 miles an hour. To me, and it also having to do with the rights of women. The history of abortion laws, they went all the way back, I think, to like 1300 in some of the things they cited. I mean, but up until pretty recently, women were considered property of their husbands and had no rights. So the idea that women's rights are shaped based on understandings that existed then, to me, it's just not the way to as we like to say, to run a railroad. It's not the way to govern. We should govern based on legal principles that make sense for today's society, not principles that made sense 800 years ago or something like that.
Yeah, and the court has said that we should look at the laws from 1700 and 1800s, and that is the regulation that can be allowed, and not the one that we are proposing today. The difference that this new Supreme Court ruling has created, I understand, is that in 2008 it was said that they have a right to have those guns in their homes for their own safety. Now they're allowed to carry those guns in public space. Is that right?
Yeah, so they decided that open carry laws are unconstitutional, guns that prohibit you from carrying your weapons outside of your house. And I should point out that one of the problems with all of the Supreme Court's gun decisions is that they state absolutely no legal standard for determining what laws are allowed and what laws are not. It's sort of left to the lower courts and to the state and local governments to guess what they're allowed to do and what they're not allowed to do. The court has not even tried to create a standard for evaluating the constitutionality of gun laws. So that makes things very difficult. So we have this situation now where we have a terrible problem of gun violence in this country, and the Supreme Court, on a case-by-case basis, with a majority of 5 or 6 people, is deciding which laws the state and local governments are allowed to have and which they aren't. And I don't understand where they think they have the expertise on how you make society better in light of all this gun violence that we have, and where they get the power and the legitimacy to do that. It doesn't seem to me to be part of their proper role.
Yeah, in light of what's happening, we're looking for more gun control, and we see the courts making it, difficult, more and more difficult to regulate day by day.